Hello and welcome everybody to today's webinar. This is our 6th session of our Women's Series webinars, and today's will be on estate planning. So peace of mind with the end in mind. It's a very important topic for us, so we'd like to present you today with some details so that you can be more informed on making decisions. So our webinar will last for approximately 1 hour today, and we will have time for questions at the end of the session. So while we're going through, if you think of some questions, you can pop those in the Q&A box just down the bottom of your screen, or you can wait until the end to pop your questions in the Q&A box, and we will go through those at the end for you. If you're not on mute, if you could please just pop yourselves on mute while we are presenting, that would be great. And this session will also be recorded just so that you're aware. It will also be uploaded to our website and can also be emailed out to you. So if you want to rewatch at your leisure, or if you do happen to miss some of it. So to cover off the fine print for today. So this presentation contains general advice, does not take into account your personal situation, but we're definitely more than happy to have a chat with you if you'd like to go through personal advice with us. So now to introduce our presenters for today's session, myself and Shannon. So Shannon, many of you may already know Shannon, here at SMART is the founder and managing director of Smart Business Solutions Group. So Shannon can assist you in many areas, mortgage broking, financial planning, estate planning, and accounting, of course. Shannon is an award-winning, innovative, qualified accountant, financial advisor, and mortgage broker, and has won many awards as well, with the most recent being on Saturday. So congratulations to Shannon, as she has won the Small Employer of the Year award. Very good. And also last year, Shannon won the Financial Advisor of the Year award and also the Goals-Based Advisor of the Year award. So a great expert in providing all of those advice areas, and she also advises other financial advisors. My name is Bianca Carroll. I may know some of you. I'm also a presenter for today's session. So I've completed my Masters in Financial Planning, passed my financial planning advisor exam, and I'm working through my professional year with the goal to become a qualified financial advisor. So Shannon and I have both completed our succession, asset protection, and estate planning accreditations to be able to provide you with the information today. So we'll go through today's agenda. So what we have on store for you today, let's have a look. We have what actually is estate planning, what can be included in estate planning, your assets. It's very important to protect your assets, why it's important, how they can be protected, what can be included in your will, what is in and what is out of your will. There are things that are included, there are things that are excluded, so it's great to know what they are. We'll go through and explain the testamentary trusts and the benefits of them with you today. We'll also have an overview of blended families. We'll look at tax-effective estate planning and also look at power of attorney. And finally, at the end, as I mentioned before, we will go through questions at the end. So what is estate planning? What is included in your estate? And what decisions can you make now? So we'll answer these questions for you today. So estate planning is very important because it ensures that you're looking after the assets that you've built up during your lifetime according to your wishes, and that upon your death that these assets are distributed to who you want them to go to, and that they're done in a tax-effective way as well. That's very important. Our role as financial advisors and accountants is not just about today, but also for our clients' future and beyond. So planning out your decisions, including your family in your estate planning decisions, is important as well. Preparing your family so that they understand your decisions is really important. It can be a very difficult task making decisions on behalf of family members when they're unable to make these decisions or when they are no longer around. It can make a time that's already emotional quite stressful and difficult. I'm just going to go on to the next slide. Yeah. So as part of your estate planning, what to consider, whether your will's up to date, whether you have adequate life insurance, the tax consequences of how your assets are distributed, implementing binding death benefit nominations for your superannuation. That's important to look at as well. Sometimes it's a bit out of our mind when we don't think about it every day. Whether an enduring power of attorney is appropriate for you, both in a financial and a medical capacity as well. And also, if you do own a business, implementing an appropriate business succession plan is important. So Shannon is an expert in explaining asset protection. So I would now like to welcome Shannon to take you through the details of asset protection.
Great, thanks, Bianca. So let's get started. Firstly, when we're looking at estate planning, it is important to consider asset protection as well. So really looking at using smart legal strategies to protect your assets so that you don't have a situation where everyone thinks it would never happen to me, or, you know, my clients and customers are fine, I would never have this implication. But asset protection is absolutely critical because it has come up and surprised many over the years. So we are actually seeing it even more critical now when we see things changing in the economy and business world, and just what we're seeing going on at the moment. It's all of a bit of an unknown. So looking at isolating assets and values from risk. So passive housing, passive income producing assets in, say, a separate business structure than an actual business structure. So separate legal entity structure than a business structure. Maybe segmenting multiple sources of risks so that any risk or liability you have on one particular area is unrelated to potentially another area. So you're not actually putting both of those at risk. And then limiting the number of the number and value of assets held by what we call at-risk individuals. So often we might be looking at who's the one that if someone's one party is an employee, their risk is probably less than that's running the overall business. So looking at how do we transfer the assets and making sure that we limit the number of assets in the at-risk individual. So some of the 5 key principles of asset protection for business owners would be looking at separating risk from assets, and then choosing a risk taker and an asset holder. What I mean by that is often we look at the risk taker, maybe the one that's running the business and the director of the business, but the other party will actually be then maybe the asset holder. They may be the shareholder of the company because they're not the one that's, in a sense, at risk as well. I do have some other strategies for if you have both parties being at-risk individuals, and that separating business risk from business assets. You know, time and time again, I've seen where I've received clients and they're operating the business with property for the business already included in that, and that does create a risk that if you do have a business problem, there's a bigger asset that someone can get their hands on. Different businesses should operate in separate entities, ideally. So again, if you have 2 different businesses, you don't have them operating in the same entity, which operationally you always can, but just from a risk management perspective, we always recommend in separate. And then regularly moving all surplus funds from the risk side to the asset side. So in the business, that might be looking at taking funds out of the business, so it's not at risk in the business, and putting that into, say, the asset side, which may be an investment, say, trust that we have in place for you. And so some of the ways that we can help business owners with this type of risk is also looking at what we call a successor director. Now, the successor director really is a must for any company owner. So whether it be yourself that you've got a company, or if you know anyone that has a business and has a company, highly recommend they look at the successor director. If you've got a single director company, which often a lot of companies are, if the director is incapacitated, cannot act as a director, or if they die, without a properly drafted will or company resolution, the business may not actually be able to operate, and the staff may not end up being able to get paid, because we can't have a situation, and an accountant kind of got dinged for this about 2 years ago, which is probably why a lot of accountants you'll hear talking about this successor director. The husband passed away, it was his business. The wife rang the accountant and said, look, I need to pay the staff, I need to keep the business going, just put me on as the director. Now, they put the wife on as the director of the company. Now, there were other disputes within the wider family, but they put the wife on so that she could keep, authorised access then to the bank account and pay the business employees and keep the business going. But actually, technically speaking, that accountant was not allowed to add the wife as a director. They didn't have the authority to add her. That's what the successor director does. So if you don't have a successor director in place, please contact us and we can help you. It's only a small amount of paperwork, doesn't cost that much at all, but it actually means that if something was to happen, there is already a document and a resolution in place that that director can take over. Multi-director company, and I've seen this happen as well, 3-director company. My client was one of the directors. The overall company wasn't one of my clients, but my client was one of the directors. 3-director company. My client actually got very sick and couldn't basically operate and couldn't do anything. And what ended up happening is the other 2 directors made decisions on the business, not in my client's best interest. And it actually cost them, I mean, it was an expensive exercise, but there was nothing that actually this director's wife could do. They had the authority to be able to do it. Whereas if you've got a successor director, you've got someone that can step in there and go through that process. So who should the successor director be? Generally, the asset holding person in the family group should be the successor director. Now, if they are then appointed as the director because something happens, we will be discussing with you again on asset protection. But what we do is we review your constitution, make sure you're able to do that. If we need to, we might update the company constitution depending on how old it is, to make sure it allows for successor directors, and then prepare the resolution, put it on file. We've got all the docs there, so if something happens. So it's a really quick and easy way, and it's only when something happens that people think that would have been a great idea to have at that time. The other one that we look at as well that we're doing quite a bit now with clients is what we call an asset protection trust. So it's called the protector. So you're building up assets, maybe building up assets personally, building up assets, on the business, super. And so the asset protection trust is really a way of trying to protect those assets from whether it be, if there's something was to go wrong, creditors or anyone coming after you at that point as well. So it's a special purpose trust, and I'll just go through what that kind of looks like. But what we are looking at doing is once it's established, we transfer the equity in your assets. So you might be the equity, even I did one recently with a client that got us to transfer, they're a high risk individual running quite a decent sized business, concerned just because of different risks in the business, and owns part of their home. So we actually took the equity of their home. Now, we didn't sell it. We actually just transferred it to, not legally, but through contract, to the trust, and then lent it back. It meant there was no tax and there's no stamp duty. And this is just important to make sure you get the documents right. So that's what we can help you with that. But it does enable you to actually have a situation where you're not exposed, even on your personal home is not exposed. So what does that look like? And this, I could probably do a whole session on the protector. When I go through it with clients, I do step through it so that they can understand what is going on that. But what you've got now today, here's your estate, all your assets go into your estate and then go down to the beneficiaries. What we do here is, in getting a gift of equity in your different assets, they can potentially go into the Family Protection Trust, which you have a separate will for on that. The Super Fund SMSF Death Benefits Trust, which has also that separate guidance and will that you can do, maybe going into Testamentary Trust, which Bianca will talk about. And then you've got not much left in your actual estate. Now, the reason this is important is estates are being challenged more and more now because of the wealth that's building up in the estates. And also, if you challenge someone's estate, you're not actually paying. So what you'll notice now is there's a lot of lawyers out there who are estate lawyers. Why? Because a lot of money involved. And it's not the person paying, the person that's challenging the estate is not the one paying the lawyer's fees. It's the estate. Now, by structuring this way, you actually don't have much in the estate that's actually available for someone to challenge. Whereas if you've got all of the assets in the Family Protection Trust and you actually have a will for that, and you have a will for your SMSF, you're not going to have, no one can challenge those parts. So you've actually got it structured quite well from that perspective. And I think this is going to become more and more important as we're seeing more litigation going on in relation to estates. There's always one disgruntled whether it be disgruntled child or someone that feels that they were, badly done through the situation. Now I'm going to hand you back to Bianca to go through what a will is.
Great, thank you, Shannon. So let's have a look next at what is a will and what sort of information can be included in a will. Very important. So a will is a legal document that details out your personal assets and your wishes for those assets. So in your will, you can include your guardian or guardians for your children that are under 18 years of age who you would like to look after your children. Your will can include your funeral and burial wishes. It can even include your funeral song if you want it to. Your will can also include your pets in it. And it can also include your social media. There's lots of different things that can actually be included into your will. Special gifts is another area, such as jewellery, gold, heirlooms, antiques, any special assets that you would like detailed as a special gift in your will can be put in there as well. Charities, if you'd like to give to a charity, this can also be included in your will. So what happens if you don't have a will? So this is known as passing away, dying intestate, or without a will. There we go. So in this case, your assets would be distributed according to the laws of the state that you passed away in or the territory that you passed away in. So this can cause a lot of stress for your family that are left behind at a difficult time. And also if you do have children under 18 left without a parent, if they are left without another parent or if they're left without a guardian in place, then they would be appointed to according to the laws of the state or territory that you're in. So it is best to have everything written down as to your wishes in the will. So the assets governed by a will. So the majority of a person's assets are governed by the will, such as your possessions, property, money in your bank account, shares, managed funds. So it is important that the assets that you own are handed down in an appropriate way to minimise tax as well when they are transferred to the beneficiary that you choose. So the beneficiary being someone that you've designated or chosen that will receive your assets, and you may choose one beneficiary or you may choose many beneficiaries to receive your assets. So what assets are not governed by a will? So assets that are owned as joint tenants. So joint tenant means when one person passes away, the joint tenant asset is automatically passed to the surviving owner. So for example, if you have a couple that own a home together, one of the couple passes away, then that home that they own together will automatically be passed to the surviving spouse. Assets owned by a company or held in a trust not governed by your will, and also your superannuation death benefits are not governed by your will. So the person's estate after passing away is managed by the executor of the will, which you can also choose in your will who you would like your executor to be. You can nominate that person. You can also have a supplementary executor as well. And then all the estate, all your person's assets and liabilities will pass through the estate and then will be nominated, transferred from your estate by your chosen executor. So let's have a look at a testamentary trust and what a testamentary trust can include next. So what is a testamentary trust? So effectively, it is a clause that can be placed into someone's will, which gives great asset protection and great tax strategies as well. So upon passing, the will maker, if they had a testamentary trust in their will, then the testamentary trust would be established when the will comes into effect. And this can be beneficial for tax effective distribution to beneficiaries, children under 18 years of age, caring for children or a dependent who is unable to care for themselves. And also it's really good in preventing beneficiaries from spending their inheritance inappropriately or too early. So just to have a look at an example of a simple testamentary trust. So upon the will maker's passing, their personal assets and liabilities will pass into their estate, and then it is the executor's role to distribute these assets as per the will. So if the will includes a testamentary trust, as you can see here, then this will be created and then the assets will pass through into that testamentary trust. So this can be property, shares, money, any other assets. And then the beneficiary of the testamentary trust can draw down income from the assets or can draw down the assets from the testamentary trust. It is important to note, though, that any assets that are taken out of the testamentary trust are no longer protected by that testamentary trust, and they can no longer be returned into that testamentary trust. So an example of how this could work would be if a will maker was to pass away and they had shares that passed through into their testamentary trust, and then the beneficiary was an adult child. If the adult child was to take the income from the shares held in the testamentary trust, they could pay their home mortgage repayments with that income, still leaving the shares in the testamentary trust as the asset held and protected in the trust, but they could still draw down that income each year. So to have a look at a testamentary trust will for 3 children, so a little bit more complex. This one is, so this can be used for, testamentary trust can be used for your surviving spouse, your children, your grandchildren. And you can also have flexibility designed into the testamentary trust so that the beneficiary of the testamentary trust can choose what they, so you can choose for them what they would spend that money on, what would they use that asset for. Also, you can put in place a condition so that the beneficiary of the trust can't access that until a certain age. So say if you had testamentary trusts for your children, you could have on there that they're not allowed to access those until they're 18 years of age, 25 years of age. But you could also have, as an example, a client example, you could have a client that puts in testamentary trust for their grandchildren, and then their client's adult children is actually the trustee of the grandchildren's testamentary trusts, and they can use the income each year to pay for the grandchildren's education. So in that way, the will maker is the grandparent of the testamentary trust beneficiaries, and they can work out a way to get their assets to the grandchildren to pay for their education. Another example of setting up a testamentary trust would be if we have a disabled person or someone that has a substance addiction and they're not able to care for themselves, and someone can set aside assets in a testamentary trust for that person, and then they can draw an income from that to pay for what they need as well. So the key advantages of a testamentary trust are the flexibility, the tax-effective distribution, and the asset protection. So the assets held in the testamentary trust are protected from divorce, from legal action, from bankruptcy. It also keeps the assets in your bloodline as well. So you're passing your assets down to your children, down to your grandchildren. And if you are passing your assets down to your children through a testamentary trust, and one of your children happens to get a divorce, but those assets are kept in the testamentary trust, and they will still be protected, and they will still stay with your child in your bloodline. Another benefit of a testamentary trust is that beneficiaries with a testamentary trust could still qualify for Centrelink benefits or age pension benefits if they have the testamentary trust, which they otherwise might not be able to be considered for under a normal inheritance structure. So the testamentary trust allows the beneficiaries to invest, change and control the assets freely. So generally the beneficiary can also be the trustee of the trust, of their own trust, if they're an adult, such as an adult child of the will maker. Or the adult child of the will maker may be the beneficiary of the grandchild's testamentary trust if the grandchild is under 18 years of age. You can also have a third party appointed as a trustee in place or in addition to the beneficiary where there is good reason, such as touched on just before, if the beneficiary of the trust has a disability or a substance addiction. So discretionary testamentary trust allows beneficiary to use, invest and control their assets freely. It's important to note that the assets, if they're taken out of the testamentary trust, then they are no longer protected in that testamentary trust environment and cannot be returned to that testamentary trust environment. So this type of asset does provide maximum flexibility for tax purposes, so that's very important. I think I've covered that, sorry.
Yep, we got.
Yep. And then a discretionary trust, testamentary trust also provides protection of your assets for your beneficiaries from third parties, as I just touched on before, in the case of, family breakdowns, divorce, bankruptcy, things of that nature. Just go to the next one. So protecting your wealth from unjust claims. So when assets pass directly to one of your beneficiaries, the assets immediately become available to anyone that might make a claim against them. So this can include creditors or ex-spouses or relatives that are not happy. So instead, we can pass the assets through the testamentary trust, and then the assets benefit from a much higher level of protection against those sorts of claims. And keeping your assets in the bloodline, as we touched on just before. So when your assets pass directly to your spouse, it's not ordinarily possible that your children are provided for, particularly if your spouse remarries or has other children. So the testamentary trust can be put in place so that you have more control over who gets those assets, even from the grave. So this can ensure that your children have a say in how their inheritance is used. So one of the main benefits of a testamentary trust is the tax benefits, actually. So children, if they're under 18 years of age, in a normal trust environment, they would be any income that they draw down from a trust, such as a family trust, they would be charged a higher tax rate, the minor tax rate or kiddie tax rate as it's known, and they don't get the benefit of the tax-free threshold in that way. With a testamentary trust, children under 18 do qualify for these concessions. So they would be able to take the tax-free threshold of about $18,000 a year tax-free income from that testamentary trust, and then any amount above that amount that they would draw down from that testamentary trust, they would then have the marginal tax rates applied to that income. So potentially they can save a large amount of tax in that way. So capital gains tax and stamp duty flexibility. So when you pass away and your asset passes to one of your beneficiaries, a transfer of that asset to another person will usually trigger a capital gains tax and stamp duty to that beneficiary. So this is because the beneficiary has a fixed interest in the asset from the time of your death. So for example, if you had two children and they each had an equal share in two houses and they decided to keep one house each, then the capital gains tax would be triggered on 50% of each house for each child. But because if the houses were transferred through a testamentary trust structure, then each child could take a single house without triggering that capital gains tax and stamp duty. So it's reducing a lot of the cost in restructuring when using a testamentary trust in that way. So giving your assets to your children over a certain period of time. So as we touched on before, you can have a level of control and be able to set certain parameters into the testamentary trust so that when your children reach a certain age, you think they might be responsible at that age to then be able to access the funds or the assets in the testamentary trust. So you can have it set for when they're age 18, age 21, age 25, age 30, any age you like, really. You can have that set for so that your child, if something were to happen to you and they were to get that testamentary trust and they were the beneficiary of the testamentary trust, then they wouldn't be able to actually access that money until the age that you have set for them. And while they are under 18, you can also set a trustee to ensure that that testamentary trust is taken care of for your children on your children's behalf. This also makes sure that they're not spending all the money all at once as soon as they get it. Not like a lottery. You want it to last.
That age is getting higher and higher over the years. I remember years ago, the age was like, oh, once they're 21, then it was 25. And I think most are doing age 30 at the moment, or they can have X amount at 25 and X amount, 28. And then at 30, they get full control of it, something like that.
Yep. Also with the testamentary trust, there is income flexibility as well. So when the asset passes into the testamentary trust, then the trustee can choose how the income or the assets from the testamentary trust are distributed every year. So take advantage of that tax-free threshold as well there. So with blended families, it is important to include your whole family in your estate planning decisions, so that nobody feels left out or less important. It's important to ensure that your estate planning is up to date, especially if there's been a divorce or marriage, because this can affect your will that you have in place at the time. So it's really important to update your will and estate planning documents after a marriage or divorce, and to also ensure that all of your children and stepchildren are all taken care for as both of you would like them to be taken care of. So let's look at power of attorney. What does this mean and what does this include? So a power of attorney is a legal document, and that's relevant to your state or territory. So the power of attorney is a legal authority, giving legal authority to a person so that they can act on your behalf. So there are a few different types of power of attorneys. So we'll do a brief overview of those. But the person that you grant the power to is called the attorney. And you may choose one power of attorney, or you may choose more than one power of attorney. So you can have an initial power of attorney and also a substitute power of attorney, or you may choose to have a couple of powers of attorney act together. So the different types of power of attorney, so specific, limited, general, and enduring. So the specific, so that enables a person to act on your behalf for one specific purpose that you can note down. The limited power of attorney enables a person to carry out particular transactions on your behalf. So managing assets while you're ill or overseas. The general power of attorney enables people to carry out any business for you or deal with your affairs and assets. This could be selling a property, managing bank accounts on your behalf. And the enduring power of attorney, so that can be put in place. That can be financial or medical. We'll go through a bit of details in that in a couple of slides. Enduring power of attorney, so that is covering you, giving power to someone to make those decisions on your behalf. So if you were unable to make those decisions any longer, then that lasts until you pass away as well. So upon your passing away, any power of attorney issued becomes invalid, and your will and executor take over the management of your affairs. So the enduring guardian, so that is for medical decisions. So you can put in place an enduring guardian to make those medical decisions on your behalf if you're unable to. And in Victoria, the enduring power of attorney is not sufficient to cover the medical enduring power of attorney. So you need to nominate like a separate enduring medical guardianship as well. Whereas the enduring power of attorney can cover financial decisions on your behalf. So to have a look at tax effective estate planning. So this is another area that Shannon is also an expert in. So I will hand you back over to Shannon.
Thank you. Thanks.
Tax effective estate planning.
Yeah. So you probably wonder why as accountants and financial advisors have we got into over the last few years estate planning? I think it's kind of this missing link. And we spend all of this time trying to help clients improve their business, grow their business, save on taxes, only to find that without, I guess, correct planning around their estate, all of a sudden, and maybe those people when they pass away they don't know because they're gone, so they don't know what's been left behind. But I've seen time and time again that just inappropriate estate planning that has made no consideration for the tax implications of it. And most lawyers are not trained to actually do the tax aspect of it. They're looking at estate planning overall. So what we're looking at is tax effective estate planning, and as accountants and financial advisors, we're working with lawyers, and there's great legal aspects of it, but there are ways, as Bianca's gone through today with testamentary trust, there are ways that you can actually help save money for or save taxes for your beneficiaries when they receive it. So it's really smart strategies, and they just need to be considered and implemented with your will. So a lot of things that, even as Bianca was talking about the testamentary trust, you don't need to go set up that trust now. It's incorporated in your will as an extra clause in the will. But we just want to make sure that when we're looking at your estate, you've built all of this money up. Let's make sure that you're not giving, a heap of it to the taxman upon your passing, that, your kids are going to be missing out on that. So looking at that, on death, any power of attorney issue becomes invalid. So your will and your executor take over management of all of your affairs. All the assets are disposed of in accordance with your will, and they may have different tax consequences. There can be capital gains tax on some of the property. We may want to think about that when we're drafting the will. So whilst the lawyers are drafting the wills, we will be in communication with them based on discussions that we've had with the client. So there's many strategies, looking at things like proceeds from insurance policies. If they're paid to dependents, they're actually tax-free. So that can be a way of actually identifying who would be a dependent that may be as looking at part of all of your wider estate, so your estate plus all of your other assets. Maybe you might actually structure your estate planning so that any insurance proceeds will be paid to this particular person, because they're going to get it tax-free. Using a testamentary trust, as Bianca's gone through, it can be an effective way to provide also an inheritance to young children. And one of that example Bianca went through, it's not a great outcome when someone obviously passes away, but working together to come in with a really great future outcome for the grandchildren, like Bianca talked about, paying for the grandchildren's school fees, and one that we worked with where we have that investment now in the testamentary trust, because unfortunately the grandmother then had passed away. But these grandchildren, primary school age grandchildren, now have this money invested. It's earning about $20,000 a year, which, because they're getting taxed at adult tax rates, there's no tax payable. It's being used to pay the school fees, but that asset base stays there and keeps growing because that's invested, and that keeps growing. This is going to be an enabler maybe for their, first car. There'll be a bit that they could maybe use for that. Could be also their first home. So there's a few things like that, or they just keep building up on the income that's being that is being earned. So it's a really nice way for you to leave funds behind and have it invested, invested. So looking at estate planning and also protection and a protection at different stages, I've kind of broken it out as to, well, what do I need to do, or what should I be thinking about? Everyone kind of should be looking at an enduring power of attorney. Looking at a will or a will with a testamentary trust, I kind of say anyone with children, you need to have a testamentary trust incorporated into your wills, absolutely. Look at getting an advanced healthcare directive, and then also enduring guardianship if you've got children as well. Anyone that's a property investor or a homeowner would want to probably maybe look at an asset protection trust using, say the protector, the gift and loan back strategy, where you're not actually selling the property, you're just selling the equity in the property, but it creates that family protection trust, which is a great asset protection. Also, just from, if something was to happen to you, and not forming part of your wider estate, and being able to have it distributed as you want, as opposed to being potentially challenged. So anything in your estate can be challenged. Anything in the family trust, remembering that the trust, or the protected trust, but family trust, remembering anything in a trust is not covered by your will and your normal estate, and therefore it can be distributed in accordance with your directions on that side. Business owners really should be looking at an asset protection using the protector. Upgrade any discretionary trusts as well to see that we can actually ensure you've got the bloodline protection and that. Successor director, if you've got a company, you really need to look at a successor director so that if something was to happen to you, and then when we are looking at estates, and if you've got a company as well, we do look at, for those of you that have got companies, may have heard of this, but we call it the Div 7A strategy, which isn't related to your director's loan. So we look at the director loan strategies from that side. If you've got discretionary trusts, clients are really looking at what we can do with any of your trusts. If you've got any of those, to look at how we can actually potentially use this protector to apply it on your trust and be able to protect the assets that built up in that. And then SMSFs and retirees. So all of our SMSF clients looking at those, again, SMSF will, because your normal will doesn't cover it. Also looking at, so interesting with super, if adult children inherit, and so this might be a discussion also if you've got parents as well, if adult children inherit superannuation funds, there's no inheritance tax, but you actually pay 17% tax. That tax is withheld. It's actually required to be withheld from that because they're not dependents. Now, if you have adult children who are clearly dependent on you because they've still got that hand coming out or you're still supporting them, they may be, we may look at putting in a dependency declaration in for those children if you are helping them on that, so that for super purposes, they may be dependent if something was to happen as well. Can look at account-based pensions with reversionary pensions built in as well. And then just making sure, always looking at the SMSF trust deed and seeing where we're at from a, to making sure that we could do this leading member, which does help on the asset protection side as well. So I'll wrap that up then now and go to some questions. I've got one question that's come through now. So if someone doesn't have a spouse, so they're a single parent, when setting up a testamentary trust, could they nominate a close friend or family member, maybe a sibling, to act as the trustee of the testamentary trust? Absolutely. I guess if you had a young child or even a 25-year-old and you don't want them having full access, you can actually nominate someone that you want to be that trustee of the testamentary trust. So it can be, family member, close friend. If you don't have any of those that you're not too sure, you could get a professional person to do that as well. But yeah, absolutely, you can do that as well. Any other questions? Yeah, but I had the one question. Any other questions? I mean, maybe we answered everyone's questions. It's a lot to take in with the estate planning. I think a lot of people think, oh, we just do a will, a bit like a will kit, but there's some of these other aspects that you can really make sure that you do it for an asset protection but tax perspective, and it kind of gives you the importance of why we're trying to link that together when we're looking at not just the estate planning will, but what is the tax planning part of it, how we can also protect it. So that actually brings to a finish all of our women's series. So if you have missed some of the earlier series, you will find those on our YouTube or through our website. Yeah, we started out as a 4-part series, but based on feedback, we created another 2. Now, of course, if anyone has some other topics they'd like us to discuss, please feel free to reach out to us. Otherwise, jump onto our YouTube. You can like and subscribe to that and you'll get notifications when we have updates. We will be recording today and that will go up onto our website as well, so that you can watch that again if you need. Feel free to come back to us with any questions, but on behalf of Bianca and I, thanks very much for joining us today, and we look forward to catching up with you all. Thank you.